I'm very pleased to present our very first speaker, Professor Ronald J. Colombo of Hofstra University School of Law, whose presentation is entitled A Legal Analysis of Religious Arbitration.
Well, thank you to the Canopy Forum for hosting this event, to Lee for inviting me to participate, and to my fellow presenters, and to those of you in our audience. With my time this afternoon, I shall provide a high-level overview of religious arbitration, touching briefly upon many subjects that others here will expand upon in much greater detail. Arbitration is the private resolution of disputes conducted outside of the state's judicial apparatus. Religious arbitration is the private resolution of disputes based upon the values, principles, and procedures established by a particular religious group. Now, religious arbitration has been around since at least biblical times, which is quite understandable. For few things touch more deeply upon a community's norms and values than the manner in which it adjudicates conflict between and among its members. The prevalence of religious arbitration in the United States has waxed and waned over the ages, but is currently on a bit of an uptick, both in frequency and in attention. This is probably due in large part to the growing disconnect between religious communities and the secular courts. Now, religious arbitration arises primarily in two contexts. The first is among believers who belong to a particular congregation. One of the conditions of membership in the congregation might be a pledge to resolve any disputes within the congregation via recourse to religious arbitration. Less common, and a surprise to some, are religious arbitration agreements within the context of commercial transactions. A religious merchant may, for example, include as a condition of sale an agreement on the part of its customers to submit any dispute arising out of their transaction to religious arbitration, regardless of the beliefs of its customers. Now, as mentioned, religious arbitration is predicated upon particular values and principles dear to its religious tradition. These values and principles might not align well with those of our prevailing secular society. Moreover, instead of a neutral judge, in theory at least, claims resolved via religious arbitration are heard before an arbitrator or a panel of arbitrators chosen in ways that some fear do not safeguard their neutrality. For these and other reasons, religious arbitration has no shortage of detractors. Some of its critics have even challenged the legality of the practice of religious arbitration. All private arbitration, including religious arbitration, is governed by the Federal Arbitration Act, the FAA. It is the policy of the FAA to uphold and enforce arbitration agreements. Such agreements are essentially subject to the laws of contract and can be struck down for any of the reasons that a defective contract could be struck down for, such as coercion, duress, unconscionability. The FAA adds to this additional safeguards, affording relief to those whose arbitrations are marred by fraud, corruption, prejudice, and even miscalculation, among other shortcomings. I look forward to what my fellow presenters here today have to say about this, but it is my opinion that the safeguards already contained within the FAA address the most common concerns raised about religious arbitration by its detractors. The FAA makes no mention of religious arbitration per se, but it is commonly understood that its provisions apply equally within that context. And such would necessarily be the case, as per the First Amendment to the US Constitution. For the Free Exercise Clause of the First Amendment precludes government from treating religious activity inferiorly to other comparable activity. This principle certainly extends to religious arbitration. A carve-out from the FAA, pursuant to which religious arbitration were held to more onerous standards, or perhaps forbidden altogether, would not pass constitutional muster. Only and unless all forms of private arbitration were banned, could potentially religious arbitration be foreclosed. Thank you.